Welcome to the Voice for Dads podcast.
Hey, welcome to this week's episode of Voice for Dads. It's a special one. I'm joined today by a former solicitor, Gordon. Hi, Gordon.
How you doing?
And I'm joined by Danielle, who is studying law.
Hi.
Hi, Danielle. We've got Gary here as well. Gary's part of Voice for Dads.
Hi.
Thanks for coming along, Gary. So I just want to kind of give you the floor. The floor is yours, Gordon. Tell us about your story. I get put on to you, so I know roughly. But for those who don't, tell us your situation.
Well, I'm Gordon Watson. I was a solicitor from when I qualified in August 2018 until my practicing certificate was taken from me in January 2024, which obviously sounds bad to people who don't know. It's a long story, but the short version is that the Law Society who regulates solicitors, they took my practicing certificate not because of any malfeasance in court practice or, in fact, any client complaint at all. It was purely for administrative breaches when I tried to do conveyancing work, which is like property law work. So I just should have stuck to my lane, basically. But it's opened up new doors for me, and I suppose that's what we're going to talk about today.
Interesting. So what is it you're doing now then if you can't practice?
So I can't practice as a solicitor, but obviously I still have the knowledge and experience. That didn't get taken away from me. So I now run a community initiative called the Free Legal Service. I've been recently assisted by the lovely Danielle Prill. She might be the face of it, actually. It's a nice face.
She's not the face so far. You're looking handsome.
Well, we need to improve that. That's for
She's
sure.
taking the picture.
Yeah, we need to get her face on it instead. No, but so it's not a charity yet, but the long-term aim is that the Free Legal Service will be precisely what the name says. It's a service where anybody can get access to justice regardless of financial means. It's not like legal aid where you have to apply for it and fill out forms and show eligibility. It's just free at the point of service. And in the long term, it will be funded by various public and private grants.
I think it's amazing what you're doing. That's why I reached out to you, man.
It sounds so good. So when did you start this year?
It was roughly December 2024.
Right.
And it started off basically as legal pop-in clinics at my local community centre. So I'd go in there once a week. People could make appointments, or they could they could basically just drop in, ask for legal advice.
Where is your clinic?
Well, there's a few now. So I'm in the East End of Glasgow, and the first clinic was at Garrow Hill Community Centre every Tuesday. My main clinic now is at Shettleston, actually in the Tesco Extra in Shettleston, because they've got a big community space. It's actually really, really good.
It's right at the back.
Right at the back.
Just,
yep.
Yeah.
Every Thursday night for a few hours.
I used to work in Tesco, so yeah, they do have community rooms, so they've gave you that room then to use.
Yep,
Yeah.
every Thursday night. Yeah.
That's good.
And actually, I'm tasked with getting a wee sign, aren't I, now, so that people can find us a wee bit easier. But it's on a Thursday night, isn't it?
Yeah, because you have to walk to the back of the store, and sometimes people are kind of getting lost. I try to explain to them that it's next to the cafe, so I really need to...
So even you can't just say it's in Tesco. You need to
No,
give directions of where it is in Tesco.
Yeah, exactly.
But I mean, the queue now outside the room is a bit of a giveaway, isn't it? Like, people must walk past and think, what are they queuing for? But it's
So how's it
you.
been going then? So that's what, 7 months, how's that been going?
It's been extremely busy, especially lately. There are a variety of legal queries that people come... So I was, just for a wee bit of background, I was mainly like a family court solicitor.
Right.
But I guess I would call myself more of a general court solicitor, because I did family law, sure, child contact and residence disputes and children's panels and things like that. But I also did really a bit of everything. I did criminal defence, I did personal injury, just anything that involved going to a court or tribunal, but definitely an interest in child law.
What's been your feedback for the advice you've given to people? Have you got positive feedback from it?
So unsurprisingly, people are really happy to get free legal advice. You know, who'd have thought, you know? So it's good so far.
And has it helped them forward in their cases?
Yes, so it started off as primarily a sort of informal legal guidance advice service, and more recently there's some scope for lay representation. So because I'm not formally a solicitor at the moment, at least, because that's all still, the regulatory stuff is all still ongoing, unfortunately. But because I'm not a solicitor at the moment, I can represent people as a lay representative. There's forms you can fill out for the sheriff court. It's more informal when it comes to tribunals and panels and things. So,
could you explain how that works a wee bit better for anybody looking for that service?
So it really depends on what kind of case you've got. First of all, if you've got, I don't know, let's say an employment tribunal case, then I just simply email the tribunal with the case details and saying that I'm representing them with their permission, of course. If for something like a family court case in the sheriff court, that's a bit more complicated. You have to fill out, I think it's called a Form 1A.2, and you have to explain to folks, you have to explain to the sheriff, there's various tick box exercises you need to do. I think it's disclose any criminal convictions. You have to disclose that you don't have any financial interest. You're not allowed, because only solicitors are allowed to financially profit from representing people. So, yeah.
Right.
What's the cut-off time for that? How much advance notice do you need to give to put that in place?
So the procedure in the sheriff court is that you can put in a lay representative application at any point on behalf of a party litigant, someone who's representing themselves. And the court will deal with the application whenever the case next calls in court. So it doesn't get dealt with immediately. It just gets dealt with as a sort of preliminary matter for the next hearing. It might be a procedural hearing, might be the proof hearing, just whenever the case is next in court.
And where's it? How does it work then at the moment if you're not a practicing solicitor and giving advice? Do you go to court with people? Can you go to court?
Yes, I can. And so without being a solicitor, you essentially need to have case-by-case approval of the sheriff to conduct litigation on behalf of someone else. So instead of me just having what's called rights of audience automatically, which a solicitor or an advocate has, I basically ask the court to give me rights of audience by way of the lay representative application. And so I do the application online, send it to the court by email, copy in the party litigant, and then the court will maybe issue an interlocutor, like a written order, or send an email back saying that this application will be dealt with on X date whenever the case is due to be in court for another reason.
What about
And then the sheriff deals with it. That's it.
What about last minute applicants? See if somebody's representative drops for representing them, a solicitor. What about last minute? How quick can you get one of them passed through?
Well, it really, I mean, as quick as you like. It depends on how quickly the court deals with it. Like I said, there needs to be a calling of the case. So there needs to be, so for example, if you had an ongoing family court case and there was a child welfare hearing coming up, and I put in a lay representative application, say, the day before the child welfare hearing, then it would just get dealt with on the day of the child welfare hearing as a preliminary matter. So it can actually be done pretty quickly. And it can be done at any time in the case as well.
So I seen your advert or post on Glasgow Live. I take it after that went out, you get quite a lot of interest.
Yeah, so that was accidental in some respects. So what actually happened was I was at, I think it was some networking event at Shettleston, and a journalist approached me. I didn't know where he was from.
Right.
I just knew some kind of journalist wanted to talk with me, so we had an interview where I was telling him about my initiative, and it turned out it was Glasgow Live, and that's just exploded interest in what I'm doing.
Because it was you that put
Aye.
me on to Gordon, and then someone else.
It was
tagged
Danielle.
us for
Danielle
that.
I
was
know
put
that's
onto me as
how
a result of that as well.
that's how I
Yeah.
met him. I saw it,
Yeah.
but I just think from I don't think Gordon's quite modest with, and I've had these conversations with how see the feedback that you've had from people just. And we've spoke about this, there's two different types of solicitors, and we are we're the ones that clients are saying feel listened to by us because, and ironically it's a free service, but we've spoken about the soft skills you need as a solicitor, and that's something that we're really good at, and trauma-informed practice and actually getting it right for the families, whether it's guardianship, employment tribunals, people are coming in just even for a little bit of advice that we don't, Gordon can't necessarily do anything at that time until they maybe get some more information, put in a guardianship, some things like that. But generally, people are saying, I've been waiting for someone like you to actually listen to them and feel, actually valued.
It's
And the
nice to get
irony-
good feedback
yeah.
sometimes.
And the irony
Yeah.
is it's free, and yet
Well, you
people
must be
are
getting good feedback doing that, though. You must be doing it because it shows that you're passionate. And
yeah. Or you you
Like-
have to be, don't you? That's
Yeah.
what we've said. Like,
People try to offer to pay me quite a lot for what
Uh-huh.
I'm doing, and I explain to them, no, it's the free legal
so-
service.
yeah.
I intend it to be a charitable
yeah.
initiative.
There's the Glasgow Live post there, 23rd of June. That was.
that's it.
Oh, wait,
So that was only a few weeks ago. So I take it it's exploded since then. Yeah.
Since then, it's been extremely busy. I think I think I'm going to have to announce a brief pause on new cases.
Yeah.
I can still give people advice at all my legal clinics I'm running
Uh-huh.
throughout the East End of Glasgow.
You're
But
the only one giving free advice round about Glasgow, surrounding areas.
well, no, there are one or two other law firms I think who also operate as charities. So like the main one would be Govan Law Centre.
Right.
I don't know exactly what they do. They are a law firm, which means that they do normal regulated solicitor work and legal aid and all that. But I think they do some kind of a free service as well, or what they call pro bono work. But as far as I know, I'm the only person who's doing it as his main modus operandi.
It's going to get to a point, surely, if it's not there already, where you think, thank God you lost your licence for a period
That's
of
the
time.
way you
isn't
feel
it?
about
Like,
it, though, isn't it?
So I have to be honest with
Yeah.
you. When I started doing this, it was just to give me something to do, you know, while the regulatory process was playing out. And because even though my certificate was taken off me in January 2024, that's not been struck off. That's it's a different thing. It's kind of like it's like a suspension while they investigate the sort of core issue of the administrative breaches that I'd done. And again, I can't stress more that my breaches were administrative. I didn't
Yeah.
hurt any clients.
Yeah.
Nobody lost money. Nobody complained about me at this point. It was just...
and
So-
have you got a rough timescale when you think you'll get it back?
I believe possibly as early as the end of this year.
Right, okay.
It goes to what's called this Solicitors Discipline Tribunal. They're like the court for naughty lawyers, basically, and, of which I am apparently one. So that's when it will get dealt with. But
Tell me more about this. I'll give them a list.
but
Open support.
but I think at the end of this year it will get sorted. Hopefully, one way or the other. I don't have much of an appetite to go back to regular practice at all. I would like to have the title back because being able to call myself a solicitor will have certain uses.
Yeah.
Like, for example, I will not need to continuously put in lay representative applications. I will
Yeah.
just be able to represent people.
But even was it Tuesday? You did a children's hearing, and they were quite obstructive with you, weren't they?
Oh,
Or
that's
is it,
out
like, it
in
was a little
Dumbarton.
bit- yeah,
So I do a
it's
lot
a
of
little
children's
bit,
panels
yeah.
as well. And you don't need to be a solicitor to represent someone at the children's panel, but it was that's maybe a case for.
But
for
I take it,
another
were they
day.
trying to penalise you for your situation?
Yeah, it's basically, they said the children's reporter started off the hearing saying Mr. Watson's not a legal representative; he's just a representative. Now, first of all, from a layman's point of view, what difference does that make? And second of all, under the Children's Hearing in Scotland Act, which deals with the children's panel system, there is no difference. A legal representative is a legal representative, whether they're a solicitor or not. So sometimes you do run into some institutional
Challenges, yeah.
roadblocks. I think that's the nature. I mean, that's probably going to get me into trouble saying this, but I've ran into some. I don't have the most favourable opinion of the Law Society either, and certain other bodies, but I'll maybe be careful what I say.
I think that's going to be one of the good points about yourself, because people feel conscious, as you're saying, people feel confident coming to you because you've not got the conflicts of interest in that. Because what we've seen is districts are all they deal with each other every day, and there's that many conflicts of interest, and people are scared to go there.
Well, I was going to add that I've got a completely different view on solicitors and lawyers from 2 years ago.
Yeah.
You know, to the point where maybe I shouldn't say this to you, but I think they're down here. You know, all the ones I've met, like they're you know, some of them are awful people. So yeah, it's definitely changed my.
I
view on
think
them.
We're nice ones though, so you found nice
That's
ones.
why I appreciate what you're doing, because it's a breath of fresh air for people that are struggling, because there's that many people out there that don't know where to turn.
Yeah.
And seeing yourselves in the position you're in as well, that they can talk to you and you're no benefiting out of it, you're just giving them neutral advice and helping them.
Yeah.
And
No,
that
this is-
very
Yeah,
rare,
definitely.
because a lot of solicitors, you know yourself, it's it's a career.
And it's about the money.
This is what I was going to say.
This
This
the
is
money. Yeah.
For me, this is a vocation.
Yes.
Which means it's just a fancy way of saying it's my calling. I know it's as cheesy as that might sound. Whether I have a certificate or not, this is what I'm good at and this is what I like to do. And it's really not about money. Obviously, at some point, I'm going to need to have charitable grants because I need to eat just like everybody else. But I'm not doing this for fame or fortune. I'm doing it just because this is what I do.
People won't mind paying you when they know what you've done in the past. And
Yeah.
this is what I'm saying, going forward, once you do get your licence back and if you do continue to practice, people will come to you in confidence because what you've done.
It's about
now.
value for money, isn't
exactly,
it?
I
And
know.
like the amount of people, and you guys are prime examples, that are shelling out for solicitors to drag it out for 5 years for, like, do you know what I mean? People offsetting her house there, you know, and people are saying to us, I am in 40 grand in debt fighting my
Not worse than that.
separation.
No,
Yeah.
no, no.
Do you know what I mean? For my children, and I still don't have access to my children properly. I'm still getting pushed back. I'm contacting my solicitor and I'm not getting responses. I'm not getting and I've come to you, Gordon, for like guidance, and like I don't know what to do. I'm at my wit's end, and it's just like how that's life changing. It's life ruining for people when they're paying this money for solicitors to basically selfishly pocket it. But
And
let's
you-
see how my career goes after saying that. But no,
What's both of your
I'll be on
views
the
on
naughty
the
list.
What's both of your views on the legal aid and that
Well-
state it's in at the moment?
Okay, so this I'm glad you asked because this is I think I've got a hot take on this.
Go for it.
So the Law Society of Scotland, which regulates the solicitor's profession, they have a sort of social media campaign just now, basically saying that there's a legal aid crisis in Scotland. They don't seem to, as far as I'm aware, they're not too specific, at least not on the social media side of things, about what they actually mean by a crisis. But implicitly, at least, what they mean is that solicitors are not that people are not getting access to legal aid for some reason because most solicitors are decreasingly involved in legal aid work. But then you have to ask yourself, why are solicitors decreasingly involved in legal aid work? Well, the Law Society will say it's because the government just doesn't pay them enough. And that's partly true, but the whole point of legal aid is supposed to be a public service. It's not supposed to be £200-400 an hour. You know, you're supposed to be doing it as a service to the community for people who can't afford the big hitters. And I can take it from me as a guy who did legal aid. Lawyers who tell you that you can't make enough money on it are talking rubbish. I made a good living off of legal aid. I should have stuck to just doing legal aid.
Right.
You know, obviously I said I strayed into property transactions. I didn't need to do that. You know, you can make a good few grand a month as a hard-working legal aid solicitor. So my opinion is that, well, the harsh assessment is that most solicitors are greedy. That's the harsh assessment, and I think I do stick by that,
Yeah.
even though it's a harsh
I
assessment. The more diplomatic assessment is that most solicitors are not interested in providing access to justice to people
Yes.
who can't afford their fees. So that's why they're not doing legal aid. So there's 14,000 solicitors, give or take, in Scotland. Maybe 1,500 of those solicitors offer any legal aid services, and even those guys are starting to back out. What does that tell you? That tells me, at least, that the profession is just driven by love of the title, the career, joining a big company,
Yeah.
setting up your own company, running a business, making money. Most people are not solicitors because they consider it a vocation, or they consider what I think a lawyer really is, which is an agent of justice.
That's it.
You know, you're not a lawyer unless you're an agent
Yeah.
for justice.
And the thing is, a lot of them will get
You're a
into
legal
it.
technician.
Yeah.
They'll get into it with good intention.
Mm-hmm.
And that, same
Yeah.
everybody in every profession.
No,
you know.
do you
It's
know,
easy to
these
lose
are-
your
these are-
soul in these.
These are questions
yeah.
that I never actually thought I would ask because they just never came to mind until you started speaking. But what's your view then? Because I've always thought, like, how can someone defend the indefensible? How can someone defend a parent who's abusing a child? How can someone defend a murderer, a paedophile? You know, how can they do that? And I always find it really interesting. What's your views on that?
So most people are not going to like what I have to say here, but I promise there's a logic to it.
Happy you
Yeah.
asked that question.
Yeah,
there.
I know. This
know.
is weird. How many conversations have we had
We
about
actually
this?
spoke about this the other day.
Oh,
actually,
God.
would say to people that if I can use a metaphor of a stage play, you know, imagine you go to a theatre, you're watching some kind of stage play. I say that the justice system is a stage play, and every single actor on the stage has their role to play. And if somebody mucks up their lines, the whole thing turns to shit, basically. So in the classic example of the seemingly sleazy defence solicitor representing a paedophile, for example, well, that's not glamorous work, of course, but the defence solicitor's job is to be as effective an advocate as possible for that individual, and it's the prosecutor's job to do as effective a job as possible to put that individual away, and it's for the judge's job to administer the rules and apply the law, or if there's a jury or witnesses, it's their job to tell the truth. Everybody has a job to do, and if everyone does their job, then a just outcome will happen.
Is there any laws in place if they suspect or they find reason to believe that the person they're representing is guilty of the crime and they still defend them?
Well, if like your job is as well, also if
complicit.
there is an issue in that warrant, like if there's been a search, if there is an issue, you have a duty as a solicitor to find that. You can only ever do the best you can for your client. You can never guarantee that I will get you off with this, or I can. But you have a duty of care, and you have a responsibility to do the best you can for that client. And that could be, you know, I can't promise you I can get you off with it, but I can get you the best result I can. If there is an issue in that warrant, or if there is something that is you found, you have to do what is right. You have to declare that, and unfortunately, that for us is the right thing to do. I couldn't lie in bed at night knowing I had, and okay, that might be a sex offender, but unfortunately, I've worked with sex offenders in the community as well. Like in my previous job, if they're in the community, I had a role to still make dinner with them, to still take them. They have to eat, so they're on 24-hour
But I
support as well.
I think to answer your question more directly, though, Gary, I've actually lost. I've lost track of what I was going to say now.
Sorry.
I listened to what you were saying.
It's because that's the thing. That is what their job is, to defend criminals.
So what I was going to say is, it's not like the American TV programs though, where you just go all out for your client no matter what, and do the most unscrupulous things. A solicitor's first duty is as an officer of the court, which means he has a duty to the court even before his own client. And that duty includes having integrity, being honest with the court. If you know that your client is guilty, then you can still do a job in representing them, even if it's just to plead guilty and deliver a good plea and mitigation to get them, you know, the fairest sentence possible. But you can't outright lie to the court. You can't mislead the court in any way just to protect your client. So there are at least theoretical safeguards in place to stop solicitors being completely unscrupulous. But obviously, when in the family court system, that's maybe not the same thing.
I'm just looking at my emails here because we've been in touch with local MPs, and we got some responses from the Scottish Government. And I'm sure there was a mention of child maintenance. I'm just going to have a quick look at this while we're talking. Not child maintenance, sorry. What we're talking, legal aid. Sorry, legal aid. But that's a really good way of putting it. The theatre and everyone has their job. That's really interesting.
The other thing I would say about legal aid as well is, and this is maybe going to seem contradictory to the first point I was making, but I actually think part of the problem with legal aid is that too many people get it. And what I mean by that is, in family court cases, so in a family court case concerning a child, which was obviously our main concern here today, you will basically everybody gets legal aid. First of all, there's two aspects to legal aid. You need to be financially eligible, and that's called the means test, and then there's the merit test, which is it reasonable for the public to fund this case? Yep. Unfortunately, the merits test is just not really applied at all in these. And basically, if you have any dispute about a child in the sheriff court, like whether you raise the action or whether it's you're defending action, the legal aid board just seems to take the view that the merits test is automatically being satisfied because it's about a child, which on the face of it seems reasonable. But the problem is, you then have just poor parents, frankly, who want to take their ex-partner to court and have a rammy. And so they apply for legal aid to fight cases where if they were funding it themselves or if they were in control of the case themselves, it would never go to court. They would just come to a reasonable agreement between adults. So legal aid is too available in some cases. It's too available to parents who want to engage in parental alienation and just abuse the court system. And then that can take me down the whole issue with the court rules and how they're not being applied, but we can maybe come to that.
I can relate to that. I can relate to legal aid being given out just too freely to parents that are even abusing their children. And because they can go to court and they've got people defending them, it's I would agree that it's been handed out.
I mean, people can go to court for some of the most ridiculous things in child contact cases, or just Section 11 actions they're called overall, whether it's residence contact, whatever. Somebody can apply to the court quite routinely and get legal aid for it easily for what's called a specific issue order to regulate some small issue to do with the child. Like, I want that child's surname changed. Most of the time, a child's surname doesn't need to be changed. At least it's not something that the public should be expected to pay £10,000-20,000 to do just because a parent doesn't like their ex-partner having the child's same name. So there's countless cases where legal aid is just being given out too freely to people who are engaging in abuse of the process.
There should be trained professional agencies getting put out there to suss the situation first, to get everybody involved, to see, to basically rat out
mediation.
Mediation
is so important. And I think it can resolve. That should be.
If you want more legal aid, public funding, then redirect it to things like mediation.
It's
get people to come together and talk, not litigate.
There is children that are at the heart of this, and like Gerfeck and Shannari, it's like getting it right for every child. That is supposed to be an easy, clean process to protect the children, with the children at the heart of the process and the system. And
even the innocent ones get through hell because it's dragged out that long.
Exactly.
And everything needs to be done, I think, instantly. It needs to be sorted out straight away. And I know they've not got the resources and that, but they need to put things in place to bring it about, because I think, see, if somebody makes an accusation, it needs to get jumped on straight away. As you say, mediation, get people in, get specialists, other agencies in to get everybody around, even separate rooms and that, but just say, right, what's your case here? What's this? You get evidence, bring it in now, we'll look through it before we proceed here, because a lot of people do waste the court's time in that and our taxpayers' money in that. And I just think,
I would actually go as far as to say most of the Section 11 cases in family courts are a waste of time.
No, and they get dragged out for that long as well, and that's one of the issues.
Within the education system, they have like Team Around a Child and stuff where they would talk about, so if a child's like struggling within a school, it's to look, is this the right placement? What can we do? What support can we put in? And I think that would be so beneficial with like mediation, getting a Team Around a Child with families. How can we resolve this without like lengthy legal battles? And do you know what I mean?
I've personally been to the Team Around a Child meetings and stuff, and if both parents aren't looking out for the child's best interest, then they're still kind of difficult, aren't they? Yeah. No matter how many people are there trying to protect the child. Yeah. So how did you get involved, Danielle? Where do you sit here?
So I just basically saw Gordon's Glasgow Live article, and I've really struggled to get any sort of opportunity with. I have tried so hard to get in. I volunteered my time once a month, once a week. I'll photocopy for any, answer the phones just to be exposed to any sort of, just hear the words. And I've been knocked back and had 0 responses consistently for the last year and a half since I've been doing my I don't know, Gordon. Why do we think?
No, it's
quite a closed
traditionally
community, isn't it?
It's traditionally difficult for any law student to get decent work experience, and then even the ones who do secure the kind of work experience, even law students who do secure work experience, a lot of the time the work experience is just to gloss up their CV.
Yeah.
They go and work for a big firm for a week or something. I've done it myself.
Right.
You don't actually learn anything when you're there. You just want to stick it on your CV because that will give you an edge in the job market later on. So even for those students lucky enough to get some kind of work experience, and most firms just are not really interested in
I think this is part of the problem with the lack of solicitors in that market.
You'd think that the wee firms would be inviting people like ambitious law students like Danielle to come in and say, please learn the ropes and maybe get a job with us later on.
Free
But
placement.
And that's what I was saying. Like, I'm like, you have nothing to lose here. Going into tiny wee firms in Postle, Mary Hill, like Clydebank. I'm driving about and I'm handing out leaflets. I went on the Law Society and I got the list of every single set, and I single-handedly, and they said, one got back to me and said, we'll put your, I made these like with business cards, we'll put it in the 92 common rooms of the Law Society or whatever.
Yeah, all the different solicitor rooms in the courts or whatever.
Zero response. And I said, looking anywhere between voluntary work and a traineeship, interested in these areas.
There's a lot of industries like that, isn't there, then? So it's like you start off as a chef or anything. It's like, we need 2 years experience.
I know.
Well, where do you get the experience?
Exactly, I know, it's frustrating.
This was a bad one for me. I was phoning up, paid all that money, and for 4 years I was phoning up 10 times a day, and you need experience.
Yeah.
Give me experience. I'll do it for free.
Yeah.
Just give me a flight, and I got one interview in 4 years, and it was a nightmare. I was basically getting told to F off.
Well, I think part of the problem is actually there's no treatment that by most solicitors don't treat being a solicitor as a vocation.
No.
It's a career.
Yeah.
So think about it. If it's just a career and a business to you, then what do you care about passing something on to an aspiring solicitor who's a law student and wants to go and learn the ropes and go out there and do some good work? It's of no interest to you because there's no commercial benefit to it. It's just. So whereas if you've got a vocation, then you might think, this person's of a similar mind to me. I want to pass on all my knowledge and experience, and they can go out and save the world one case at a time themselves.
What do you think is a solution for that? To get more experience and to get more solicitors on board to bring down the waiting time and that?
I think this is I think.
Well, what email have we just had there? Gordon. So I'm waiting to get into the diploma.
Oh yes.
And so this is actually hits the nail on the head. Gordon sent. I got knocked back. It's 3 rounds. I got knocked back in the first round, and then the second round is the 24th of July and the 5th of August. And so I said to Gordon that when I did the application, there was no opportunity for me to put that I've got 17 years experience working in homelessness, addiction, children's homes, domestic violence, and all those, the huge, both in England and Scotland. No opportunity for me to put my...
They just cared about her grade point average, which is slightly less than some other students,
yeah,
so therefore she's not deserving of a place on the course.
And then they knocked back the email and said that, and it was an amazing email, and like my family and everyone was like, whoa. And then they've just emailed saying this isn't really relevant. It's based on her grades. So,
which, by the way,
cheers.
my grades were not exceptional either. I think my grade point average was like 62% across my degree, which is decent.
Yeah,
but it's not.
It's
not an A student.
No, and that's what.
And it didn't make a difference because even though my regulatory situation is not great just now, what I did was, I had a huge amount of experience doing frontline work. Sorry, you were saying.
I was just obviously to put things could be put in place, obviously, to change this, to going forward anyway.
Certainly, my initiative was a one-man band until recently, just me giving people a range of legal advice and in some cases representation because I was a general court lawyer and I did really a bit of everything. So I was doing that as a one-man band, but obviously Glasgow Live article came along. Quite a few students were interested in shadowing, basically, which is great. I'm happy. I've said to all these students, I've said, look, come along and observe because...
So is there more people involved now in the clinic?
Well, not really. I mean, intermittently, because most law students who do want to observe something like that, they just want to observe occasionally, maybe learn one or two things. But I think, frankly, probably most of them are not that interested after a while because... It's not working for me is probably not going to gloss up your CV all that much, even though what I'm doing is far more meaningful than any placement that you'll get in some big corporate firm. Obviously, it's not the same thing. It's not the same sort of status symbol, if you like.
See, when you're representing somebody with the layman's, can you take someone in with you? Would you allow that?
Yeah. So what I do is when I'm dealing with the service users, I suppose the people who come to me are service users rather than clients in the formal sense of the word. But even though I'm not a practicing solicitor just now, I just treat confidentiality the same way I would if they were my client as a solicitor. They get full privilege, they get confidentiality. Even when Danielle, who's more fully involved now in terms of the administrative and basically a sort of quasi-paralegal role, helping me with research and stuff and being fully interactive at clinics, not just observing like all law students, but being properly engaged. Even when Danielle's on board, I do ask these people, I say, oh, by the way, do you mind if I share details with your case with this law student who's helping me out? So I suppose formally I'm not bound by the same confidentiality stuff, but I don't. Because that's the right thing to do.
Yeah, it's professional. Yeah.
So back to my question earlier on about how that a time will come where you think, I'm glad this happened. I think that's gonna. It's already came, to be honest with you. That's good.
Like I said at the start, in December last year, I started my legal pop-in clinics as something to do, just to keep my mind fresh in terms of the legal work. But then when I expanded the clinics, and now it's up to 4 clinics across the East End of Glasgow, multiple clinics a month, and the sheer range and density of queries that I'm getting, it actually even caught me off guard. I didn't realise just how many people were in pretty desperate situations, some of them, because they've just got... The amount of times I've had people come to me saying, I can't get any solicitor take on this case, or I had a solicitor but they're not doing a good job. And we're not talking about, the occasional nutter that might come along with some nonsense case. We're talking about
which
people
we love also, by the way, because we're also part of that squad.
They don't really come along very often, in fairness to them, but it's these cases that I'm helping people with. These are some really major cases. I can tell you without disclosing the names of the people involved, I'm dealing again with what I think is possibly the worst family law case that I've ever heard of, and I dealt with a lot. And this guy, I actually think, I won't say his name, but I actually think you might know who I'm talking about, because he's mentioned your name before. This guy was married to a woman. They had 2 children together. They went through divorce proceedings, I think, around 2019. There was then separate contact proceedings because she wasn't letting them have contact. There's a psychologist report lodged in process as part of the evidence of the case that this woman is Machiavellian. That's the quote of the psychologist, and a danger to her children in a similar way that a sex offender is a danger to children. That's actually what the child psychologist said of this woman. So he got an interim contact order that was due to take place one Friday afternoon, and he discovered that she absconded with the children. I think first of all somewhere in Eastern Europe, maybe Poland, and then later to a rogue sort of de facto state called the Turkish Republic of North Cyprus, I think it's called.
I was going to say somebody done it to Cyprus. I read in the paper not long ago.
And apparently there's a whole internet community online where women who are similarly scheming, or maybe dads do it too, I don't know, but so I don't want to be sexist. There's arsehole men and women out there, frankly, and I've dealt with both sides. But there is an internet community where people get together and say, well, if you take your children to this place, there's no Hague Convention there on child abduction. There's no extradition treaty with your home country. Take them to Costa Rica. Take them to the TRNC.
Actually advising people where to run away.
Advising them,
with their children.
Yeah, telling them that this is how you can get away from the law and Interpol and things like that. So this guy basically had 0 contact with his 2 children for a good few years, actually. Went from solicitor to solicitor, ended up stumbling upon me via a mutual connection. The complicating factor is I actually represented this guy as a solicitor when I was practicing, but then I had to stop representing him because of the suspension stuff. But he's actually so dismayed with his actual solicitors that he's come back to me anyway to help him in a more informal capacity.
What's the reason for that? Why are the solicitors not picking up these cases?
What are you saying? They just wasn't happy with the solicitor?
Yeah, so either they're not picking up the cases or they're just not doing a great job, a lot of them. Not all of them.
It out.
Yeah, just, like... I'll submit my interim fee account in 6 months' time. It's just complacency, I suppose.
So I've heard a lot of solicitors asking if their case is already gone and refusing them. That seems to be a thing as well. If it's not a new case, if it's an already ongoing case, it seems to be a thing.
Which I never understood, but that does happen a lot. A lot of solicitors will not take on cases that are ongoing.
Yeah, I'm aware of that. Yeah.
I've heard a lot of that.
But this guy, anyway, didn't see his kids in years. When he came to me, I had the idea of lodging what's called a minute of amendment, which is where you change what you're asking the court to do. So his was like a basic Section 11 case to begin with. I think it was just a contact action. He was asking for contact. I said, no, let's amend the action, throw in deprivation of parental rights against her X, Y, and Z, because I thought to myself, with that kind of psychology, if you threaten to remove all of her parental rights, and she's a non-lawyer, so she doesn't know that it's going to be difficult to enforce that in a different country. I thought, this will actually make the woman pop her head out of the trenches, so to speak, and she did. And then he ended up getting some contact. There's now complications again, but that was the worst case. Yes and no. He did. We got him some contact, and then I got suspended, and then things kind of went to shit with his new representation, I think, and now he's come back to me to try and resurrect it.
But for such a report from a child psychologist as well, to highlight the danger that the mum is, and for her to be left, can you imagine it was all the way around?
It's another big question.
No, it's some of the stuff I've seen is crazy.
Another big question I've spoke to you about it as well. It's trying to understand, because it's not just the males, it's females as well going through it that obviously suffer too.
Oh, I've seen plenty of bad dads out there too.
Oh, there's both sides, but obviously for some reason, it still to this day seems to be the fathers that get the worst representation in that, depending on not all the time, it's changing, but it's still happening. You still see it and we still hear it, what's going on. But I'm trying to understand the way the only way I can explain it is like when you're doing your driving test. I think it's a solicitor based thing, because they maybe talk to each other and kind of basically sort out like plea deals and that, because it's like doing your driving test and you get told best time to go is a Saturday at a certain time, because you can only pass so many. It seems to be that's the case I've got, because it seems to not be specifically an individual. It seems as if they've got to have so many cases they're sharing or something. Do you have any explanation on how that is? Because we've heard this stuff, like some of the things that with the evidence in that, you think, well, it's like giving common sense.
So you mean like why the process just seems to disregard? Because you hear a lot of like party litigants or to say, why is my evidence not being considered? And they're just genuinely confused why they got all this evidence and the court doesn't seem to care about it.
Hearing the identical case that's got a completely different outcome, and that's what I'm saying. It's no, everybody thinks it's
that's
courts,
common.
the courts and the solicitors are going against them, but it's no that. I think it's I think there's something bigger behind it, and I think it's all amongst the lawyers and the solicitors within the district. I'm not saying them all, because I know some of them are independent in that, hence the reason, obviously, yourself and some of the other ones I was looking into at the time, with stuff we've been talking about, is you get independent ones only within the clique. But there seem to be a lot that seem to have a lot of conflict.
Jobs for the boys, the boys' club.
And they're all connected, the social work, the courts, the solicitors, they all talk. And it seems as if, like, it used to be, for what I remember, what I think it should be, is people used to value their reputation as a solicitor in winning cases. Now it doesn't seem that way. It's as if some of them just give up in that.
Well, reputation nowadays, at least, is not synonymous with winning cases. It's more just about getting on with your colleagues, getting on with the court, making a good living.
That's what I'm saying. This is a worrying thing.
And there's probably, I'm sure there's a few lawyers out there who actually, want to go to proof or trial and win. And don't get me wrong, it's good that cases can settle, but a coerced settlement is not justice at all.
Well, that's why I'm against plea deals and that as well. You're either guilty or you're innocent. I don't agree with.
Well, there is some merit for plea deals, but that's a whole other topic.
I know that's criminal based in that, but but it's to me it's like they're making up something that isn't 100% what happened. And as I say, as a law, I think it should be acted on to get to the root cause of what the actual problem was.
Right, so I think to address what you're getting at is there's a lot of procedural inertia in family court cases.
Was that right? Sorry.
Is that right? Yeah.
Sorry.
There's a lot of sort of procedural inertia in family court cases. So what I mean by that is Well, as you both probably know by now, when you raise a court action or you defend a court action, it doesn't just go straight to an evidential hearing like a trial or what they call a proof in a civil case. It's not like court actions raised on paper and then tomorrow you've got an evidential hearing in the case. There's a whole lot of procedure between the start and the end. So first of all, it's getting people to grips with the idea that there are procedural callings of the case that don't involve evidence at all. But the complicating factor with family court cases is we have this little thing called the child welfare hearing. Now, if you look at the actual court rules, the child welfare hearing, the purpose of a child welfare hearing is to, quote, secure the expeditious resolution of a dispute in relation to a child. In other words, get this case resolved as quickly as possible because that's in the child's best interest. Inexplicably to me, what actually happens is instead of having like one or two expeditious child welfare hearings to really knock heads and sort a case out, or if we can't agree, at least identify quickly this case needs to go all the way to a proof hearing for evidence to be led. What you then happens is you get like umpteen child welfare hearings spread out over months and delays and delays and delays and the case gets sisted or paused and or there's mediation, it never really goes anywhere, and cases can go on for years without ever going to an evidential hearing. Just two parents or one parent using the court process, which is also publicly funded, by the way. Nobody talks about that.
Yeah.
The courts are funded by the taxpayer. So when you have dafty parents going into the court just abusing the process to fight their ex-partner, that's doing as much damage as it is when they apply wrongfully for legal aid.
And you're at the bad end of that and you're having to pay against somebody that's maybe getting legal aid, and your reputation, everything's been tarnished and nobody's been held responsible as well. It's another big thing in it. It seems to be.
So see, getting to proof, what happens at proof? Like, can you give anyone listening an insight as to what a proof is?
Right, okay, so a proof, in simple terms, a proof is just what they call a trial in a civil case. Probably people are more familiar with the term trial because, even if you don't know much about law, we've all seen trials in TV programs and stuff. So a proof, like a trial, starts off with in a civil case, it's called the pursuer, the person pursuing the court case. They're a party to the case, and then the other party is the defender. So pursuer versus defender instead of prosecutor versus defendant, basically, or accused.
And the pursuer being the person that wants to see their children most of the
so
time.
for example, let's just say it's a bog standard contact case. The pursuer is a dad who's wanting a contact order for his daughter, let's say. The case ends up going to proof because there's no agreement between the start of the case and the end. The case needs to be dealt with by a final order of the court after hearing evidence. So then when it comes to the day of the proof, the pursuer generally goes first, which means there's no opening speeches or anything like that. It just goes straight to calling witnesses. So the pursuer might call themselves as a witness, for example, and their solicitor will ask them questions.
Right.
That's called an examination in chief. That's like the open-ended questions, like, can you tell us your name and address and occupation for the court and tell us about what happened on the 7th of July 2023, like that kind of stuff.
Yeah.
Then the other solicitor will have the opportunity to cross-examine that person. That's more like, so on the 7th of July 2023, you slapped that woman, didn't you? That's a closed question. And then what happens is the same process repeats for the pursuer's next witness and their next witness until they don't have any witnesses and they close the proof, basically. Then it moves on to the defender to do the exact same thing in reverse. And then once all the evidence is dealt with, you have basically a hearing after evidence. You have like closing submissions, if you like, where both sides get to comment on the evidence that's been led and what the relevant law is and what the court should do, and then the court will go away and decide what the order should be. And that, just like a trial, that's the structure of a proof.
So there's no jury. This is for anyone listening. There's no jury in a proof.
There's no jury in family proofs anyway. It's possible to have juries in other types of civil proofs, like big personal injury cases or something, but not in this.
And why is it behind closed doors and recordings and that aren't allowed and stuff? What's the reason?
Well, the whole idea for closed doors, I think, is that it's a child-sensitive subject, and so normally justice has to be seen to be done, not just done. That means that the public can sit in and watch a case, But in family court cases, their justification for these all being private hearings is because it concerns like a child.
Privacy, yeah.
But on the other hand, that could also be abused too, because you know, people aren't seeing what's going on behind closed doors, so to speak.
So then it's a sheriff that takes the outcome of a proof.
Yes.
And that outcome would be typically 50-50 contact, or what would it be?
Well, it could be, it really, that's just case specific at that point. The sheriff could say, no, you're not getting any contact, it's not in the child's best interest, or they could say, well, you'll get contact every second weekend, or they'll also typically assess what level of contact should be had throughout the year, including school holidays and things like that. Or and what really should happen in most cases is shared. There should just be shared custody in basically every single case. Like, we should start off, and that's a legal problem. I think there's no presumption. There's no presumption of shared custody or shared residence that the courts start off with. Every single child, by default, should be entitled to equal time with each parent.
Yeah.
That
But
should
the
be
law
the default
doesn't.
starting position.
Yeah, but
that's
the
what
law
we're
doesn't
fighting for.
actually explicitly set that out at all. And so really what often happens is whoever raises a court case first is at an advantage, or more specifically, whoever throws mud at the wall first is going to secure an advantage, because they can use that mudslinging to secure what's called interim orders.
Yep.
Like, you can get an interim contact order long before you get, or you can get like an interim interdict, say. An interdict, like, is just a Scottish term for injunction. An order stopping you from doing something, like stopping you from approaching your child, or stopping you taking your child on holiday or something like that. So what happens is with interim orders don't actually need evidence to be granted, which sounds crazy, right? An interim order is, if you want an interim order, you just have to persuade the court that there's an urgent need for the order, and that you have a prima facie case, like a case on the face of it for the order being granted. That means, like, without an inquiry into evidence, just on the face of it, is it reasonable to grant the order? And then the balance of convenience has to favour that guy getting the order as opposed to the other guy suffering from the order being in place, let's say. So that's called an interim order, which can sometimes exist the entire lifetime of a case.
Yeah.
And I think interim orders are needed in principle, but I think sometimes you can have a lot of interim orders, or the existence of interim orders can just basically drag cases on forever, because, you know, there's already a measure of legal protection or persecution, depending on your perspective, in place, without need to go all the way to proof.
And what happens after proof? So say proof they put the child first, right? The child's 50-50, you know, equal parents, and the child's having their best life as they can with parents have separated. What happens if one parent then breaks that order?
In practice, not an awful lot, a lot of the time, frankly. And I think you already know that. But in theory, that's contempt of court. But it's not as simple as somebody breaks an order and they're immediately held accountable for it. You need to basically prove that person breached the order. For example, a mum might say, or a dad might say, I'm not giving Jimmy over for contact this weekend. And then when confronted about why they didn't do that, they might say, oh, well, he was sick.
Yeah.
And on the face of it, that's might be a justified reason. You know, if he was too sick, he had a contagious chicken pox or something like that, I don't know. So sometimes it might be appropriate, and it is legally justified to not follow an order temporarily if there's some kind of emergency like that. But of course, a lot of people will just ignore orders altogether, and then the onus is on whoever wants the order to basically lodge what's called a minute for contempt of court, basically a side court action attached to the original court action, so that they can try to persuade or prove to the sheriff that this contempt has taken place. And then even if they're successful in doing that, which, by the way, requires time and attention and funding, even if they're successful in doing that, I could be wrong, but I personally haven't heard of a case where the other parent in contempt was sent to prison for a family court case. I do recall one case, I think maybe around about 2018 or so, the name escapes me, where the mum had a prison sentence, but that was removed on appeal. So she never went to prison. It was deemed like too harsh a punishment for the contempt, even though this woman.
So what would the punishment be? I thought prison would be a good thing because then
no,
the
because
child's
it's kind of
missing out.
Isn't it?
Yeah.
So it can be.
But what would the punishment be then?
It could be. Well, it could be theoretically a prison sentence. It could be a fine. It could be both. I forget the exact tables. I think it can be up to 3 months in prison, and maybe possibly up to £5,000 in fines or both. But usually, fine and or imprisonment.
What about appeal processes? How does that work, even with like a proof? See, because I remember looking into it a while back, and if you don't get your solicitor to shout for appeal at the last hearing to take it further, it doesn't. It's exempt. Like, you need to do it in the last hearing. Is that right?
No, you have a certain number. It's different for different types of cases. I think the general rule is, and I could be wrong here, so I didn't do a whole lot of appeals in my career, but I think it's 14 days after the interlock. So the interlocutor is what you call the written order. Yeah. You generally have, I think it's 14 days after the date of the decision to appeal the decision that you want to appeal. But an appeal is not a retrial. It's not hearing evidence again. You can only succeed in an appeal if you can persuade the appellate court, like the sheriff appeal court in the first instance. If you can persuade them that there's some kind of procedural irregularity, or that the sheriff applied the law incorrectly. Like, for example, if the sheriff said, you're not getting a contact order because I don't think that's appropriate, that would arguably be an error in law, because the test is the welfare test, which is that what's in the child's best interest, not just what a sheriff personally thinks.
Yeah, right.
So that would be an example of like a procedural irregularity or an error in law. So, but short of something like that, then you're not going to win an appeal. What you would in practice do most of the time in a family court case is you would just go away and lick your wounds. And then maybe a year or so down the line, when you can come back to the court and say, I'd like this case to be reopened on the basis that there's been a material change in circumstances. Like, this child is now much older, or they've moved to a new school, or something else has changed in the parents' lives. So
okay.
What about, see, welfare reporter goes and does a welfare report, and then the judge will have learnt on the reads the summary, and that, because let's face it, they've not got the time to read through every single case. What if that welfare solicitor's got things wrong? They've not been given the right time to get the full story in that.
Yeah.
What's your views on? You witnessed a lot of that. You came across a lot of that when you've been.
Yeah, sometimes child welfare reporters do get it wrong.
But what about the judge on the reading the summary for his conclusion?
Well, I don't know too much about that, because the sheriffs have like I forget what they call it, but it's basically they have like a reading day, or they're supposed to have a day before so that you'll have like a day where they've got maybe like 20 child welfare hearings or something, but the day before is when they're sitting in their office reading all the papers for the cases. Whether they actually get round to doing all that or not, I can't really prove one way or the other, but that's supposed to be what they do.
That was one of the things the Scottish Parliament got back to us on, was the child welfare reporter is going to be a register. So they're all going to be, they have to be regulated and stuff more than what they are.
The child welfare reporters, basically, in a sense, they're regulated by two different bodies, I suppose. A child welfare reporter is a solicitor, right? That they're just a local, experienced family law solicitor that's respected by the court. Yes, basically. So they are an independent solicitor who's not representing a party to the case, appointed by the court, because the court has like a list of child welfare reporters. They just pick one that doesn't have a conflict or anything, obviously. And then this child welfare reporter produces a report that belongs to the court, not to any of the parties. Now, either of the parties could theoretically then call the child welfare reporter as a witness at a proof hearing, but in practice that doesn't actually happen most of the time. What usually happens is child welfare reporter does a report, gives a recommendation, and even though it's just a recommendation and the sheriff, is up to them what they do, I think in practice that child welfare reporter's recommendation is going to be closely mirrored in the actual decision of the sheriff. So that basically creates a process where you can have cases effectively determined by child welfare reporters without evidence.
I was glad when I heard that they're going to be more regulated, kind of more scrutinised, because I personally know of one that should never be allowed near a family court after
Yeah.
the report she done,
Oh my God.
and it was just so
That's
incompetent
worrying.
to the point where she admitted to another lawyer that she'd screwed up, and I thought, this is children you're talking about here, and fucking it up.
I don't know about your district and that, but our district, there's a strain on welfare reporters, and now they've got the curators. What's your view on curators?
So the curator's a different role from a child welfare reporter, but it's my understanding, I didn't see a lot of curators in practice. It was mainly child welfare reporters. I think a curator is also just a solicitor.
It's a solicitor, but they're put.
It's appointed under a different rule, but they basically do the same job as a child welfare reporter. They well, actually, not strictly speaking. A child welfare reporter is like appointed to carry out some kind of inquiry, whether that's to speak to the school or speak to the child or whatever. A curator is more someone who's appointed in the interest of, like, say, the child. So practically speaking, it's basically the same role.
Am I right in saying welfare reporter is split between the two parties? Curator is the pursuer.
No, a curator can be appointed for a different thing. Think about the curator as being like a child welfare reporter, but their role is much broader.
I mean, how they're charging for the case. The welfare reporter is split between the two parties,
Oh, right, I see.
whereas the curator is only for one party.
Right,
It's the
so
person, and they can extend it. I looked at a case up in Edinburgh, and you can Google it. It was, I think, up to £15,000 they charged, and they kept extending it, but they've got to ask permission.
Yeah.
To keep extending it, and they keep going back and forward.
No,
back
my
and forward, and
understanding
it's
is
not
that
limited.
the curators are, I think it's the same default principle where both parties are expected to equally cover the cost. What actually happens a lot in practice is whichever party has legal aid, the sheriff will usually order that the cost of that report are covered under their legal aid certificate. So that's potentially another abuse of the legal aid process, not because the sheriff is abusing the legal aid process, but because of the fact that there's people out there who shouldn't have legal aid to, engage in parental alienation, who then get it, and the public is paying for a £6,000 child welfare reporter or curator or whatever the case might
And
be.
is that no putting strain on individuals if they've got a cap on the...
The cap I think you're referring to is the legal aid cost limit.
Yeah.
But that can just keep getting raised if you keep asking the legal
right,
aid board. I mean, you theoretically you could have a cost limit of like £100,000 if you wanted to. Whether it's actually going to go
asking, don't you?
you just keep applying.
Yeah. So for folk listening, if there's dads, well, there will be dads listening, and they'll be in a situation where they either won't be seeing their children or child at all, or it's just a battle, having to deal with just shit all the time, fighting. How would they get in touch with you if they want to speak to you, if they want to ask your advice?
Right, so, I've got my Facebook page. It's quite a basic setup. It's the Facebook page. It's called The Free Legal Service. I think you've got it up there.
Free Legal Service, yep.
So just like my Facebook page and message me.
Right.
Or if you prefer emails, you can ping me an email. My email address is thefreelegalservice
That's gmail.com.
gmail.com. We also have a second email address now that I've not added, and that's an email for Danielle, actually.
Yep.
So because I'm now getting such a full
Are you
inbox that
keeping
I
on
want to
to-
make
Yeah,
sure
so I've
people
got,
are getting covered. I think I've got like 90 emails I still need to deal with or
So
something.
mine's just Danielle, thefreelegalservice
Have
@gmail.com.
you represented anybody yourself?
No, I've just kind of
It's kind of like a
Shadowing.
paralegal type role.
Yeah,
She's
sure.
helping me out basically.
One
But
day, though.
One day she will be
He's a
representing.
He's a clever
people.
cookie, though, isn't he?
Yeah.
Yeah, I'm learning loads.
So yeah, that you're definitely going to get folk reaching out. So you're on the back of just doing this.
What I would say to those folks then is, if any dads who, I'm really busy just now, so there's no guarantee that I can actually represent you in the way that we talked about, at least for a short period of time. But at the very least, if you reach out to me, then I will call you and I will tell you how to conduct a case in the sheriff court yourself without a solicitor. Because I'll basically just tell you this is what a solicitor would do. This is the process from start to finish. This is how I think you should approach it strategically. So I can, if worst case scenario, if I just don't have the time to take on someone's case in a more formal way, I can guide them behind the scenes.
I suppose even that's a question.
And I can help them draft
the-
court papers and stuff like that as
Yeah.
well.
That's
the
what
dads,
I was going to ask.
that dads don't know that you can represent yourself.
And that was my next
Yep, you
question.
can.
See, for example, if you're too busy, you couldn't represent them. what's the Mackenzie friend in the lay?
Yeah,
thing?
so
Could you explain that in case somebody wants somebody to come in to represent them? Or
right,
how
so
you go about it?
there's two different things. There's the lay lay representative in the sheriff court, which is an application that the person who wants to represent you would complete, and they'd submit it. It's a dead simple application. It's like a page long. You just fill out like the name of the case and the hearing that you want to represent somebody, and you tick the list that you've not, or you know, you list any convictions or whatever you might have if you've got any. You disclose importantly that you don't have a financial interest, that you're not getting paid to do it because you're not allowed to get paid to do it. So there's a form where you can be a lay representative.
It's a cash in hand job then.
No comment, Your Honour. No comment. But no, so you can do it that way, and it will be up to the court if they want to appoint you. Or a more informal role is what you said, the Mackenzie friend. That's what they call it down south. I think up here they call it just a lay supporter. So lay representative.
Yes, a lay representation form.
That's okay. So that's not the same thing. So that's the for simple procedure, which is just cases up to financial value of £5,000. So that wouldn't apply for a family case. If you actually look up a form 1A.2, if you can type that in.
That's their ordinary case 1A.2. Is that
Right. So if you click on that, I'll just to show you what the form actually looks like that your lay representative would complete.
So this is someone that's going to come in with you, or someone that's going to come in and represent you.
Yeah, so a lay representative would actually speak on your behalf if they're appointed by the court. It would be like your lawyer in court. They would stand up, do all the talking for you, all that kind of stuff.
Okay.
A lay supporter, there's no application form for that. You just, turn up at court with somebody who's supporting you, and ideally you let the court know in advance, particularly because they're closed hearings. The sheriff might be like, "Who's this guy?" Mm-hmm. But the court basically have to allow you to have a lay supporter, unless the particular person you bring along is like a known pain in the arse to the court or something. Like,
so they can't say no, obviously.
They can technically say no, but they're not going to say no. If you've got like your friend and he's, quietly sitting next to you taking notes or whispering in your ear, they don't speak on your behalf. They're just there to give you sort of moral support.
Give you advice as well while you're there. Can they pull you?
Yeah, they can do that. That's a lay supporter can have a quiet word in your ear and say, "Oh no, I think you're doing this wrong." They're just not allowed to talk on your behalf.
What about a lay representative or even a solicitor representing you? See, with speaking, like say for example, your solicitors representing you and they maybe get something wrong, or they get asked something, they get cross-examined something, they don't know the answer. For what I've been made aware, you can't just stand up and butt in. And how does that work?
Some court etiquette required sometimes.
I think it's shocking. To be fair, I think you should be able to defend yourself.
It's a good question. So, first of all, when the court appoints you as a lay representative, you basically have the same status as a solicitor. You're not a solicitor, but you're representing the person in the case. So the court will generally want to hear from one person first. They'll usually hear from the solicitor first because they kind of defer to the solicitor, understandably, because they're officers of the court and all that kind of stuff. So they would maybe hear from the solicitor for the other party first, about what their position is, and then they would turn to you, the lay representative, not the person that you're representing, but you are basically that person's lawyer. So you do the talking. That's what a lay representative is. You're just a solicitor without a gown, basically.
See, for example, if they were maybe to forget something, or like maybe someone was asked that they've no went over.
Yeah, they could.
Don't mind you just nudging and saying,
yeah. So especially in like a child welfare hearing, which is a more informal structure, like sometimes the sheriffs will just go right over the solicitor's head and talk directly to the party. So like there's wiggle room there too.
I was made to believe that judges don't look that greatly on you speaking over a solicitor or somebody representing you. Like,
you should always
no making expression, basically, in a sense.
Yeah, that's just normal etiquette, though. That's not like a rule per se. Like sometimes you do need to talk over somebody if they just won't shut up, and you have to make an important point.
Drop your solicitor during a case if they're no.
Yeah.
Aye, so that is
any point. If you sacked your solicitor, they then have to send an email to the court formally withdrawing from acting. That triggers a procedural hearing called a peremptory diet, where you turn up at court and the court basically says to you, "What's going on? Are you going ahead with this case? Are you getting a solicitor?" "Yes, I'm doing this, X, Y, or Z."
And the solicitor could also ditch a client, which is quite
no.
It's quite interesting. So
but during the case, see,
they're not. A solicitor's not supposed to do that unless they're not supposed to just unilaterally, especially later in the case. They can actually technically a solicitor can get into trouble with the Law Society if they just abandon you
Just abandon
late
Or
in the
they'd
case
have
without a good
wouldn't
reason.
they?
You know,
yeah.
it's got to be a solid reason. Like
Yeah.
even non-payment of fees sometimes is not a good enough reason.
Is it not?
No, sometimes, especially if it's like a really late in the case and there's a lot going on or something. So.
Yeah.
A few cases of that. What was I going? It's during the case. See if they're misrepresenting you while you're there. They're maybe kind of going against you in your own case, or maybe saying stuff that's not true.
Oh, you mean like sack them during the hearing?
During the hearing.
I mean,
so, can you stop representing me? I want to speak now. Is that a possibility?
You'd have to be very clear about it. That you're actually. It's not just that you want something to say something. That you're actually terminating your solicitor services.
Aye, but maybe if
that
you've
would
asked
kind
them to say something in your behalf and they're refusing to say it,
Till they come out.
Yeah, you just have to
Fuck
wait
that.
until they come out normally.
that'll be too late to get your point across.
Well, or you no. What a lot of people do is they just say, a lot of people say Your Honour because they just do it. But it's like my lord or my lady,
Lord,
right? If you
yeah.
want to get into the court etiquette,
Yeah.
my
But
lord, my lady,
Aye.
you can just interrupt your solicitor and just say, oh, by the way, I'd like to say something. That sometimes the sheriff will say, I don't want to hear from you if they're like a grump. Though I'm hearing from your solicitor. I don't want to hear from you. Or sometimes we'll just say, okay, what is it?
So that's what I'm saying. Maybe just to tell them to sit back while you kind of take over and represent yourself in the case.
No. So you can't really do that, no,
Nah, you
because that person's your representative. You either sack them or you keep them. You can't have a middle ground.
Aye, but it was just if you're in. Ken what I mean? If you're in the setting where there, maybe you've told them, like, I want this across to the judge, I want you to say this, and they're refusing to say it.
Find
and
another
you're-
solicitor.
Yeah, you just get another solicitor
Aye,
or
but,
lay rep.
but
I
if
guess.
it's too late, if it's basically they're about to make that decision in that case, could you then say, all right, if I represent
I've never
myself
seen it
going
happen.
forward,
I've never seen it happening before, but strictly speaking, there's nothing stopping you from
stand
putting your hand up and saying, "I'm sacking him as my solicitor right now,
aye, then
and I want to
represent
speak."
yourself. Aye, no,
I've
that's-
never seen that done before. That'd be kind of crazy, but
Aye, but it's a possibility.
you could do that.
So I thank you very much for coming in, both of you.
Yeah, you're
welcome. us.
I definitely think that your clinic's going to grow and grow, and I think you're definitely on the right path to, something special here.
I just need to
Thanks.
keep up with the admin because as good at the law stuff, I suck at running things. That's part of the
That's
reason
kind
why.
of my
I
job
think
now.
surely the amount of
Yeah.
students that, like we're talking
Yeah.
about, are struggling to get just work experience.
Oh yeah,
Yeah.
if competent students want to come along and help me with
Yeah.
my emails, then send me. Don't even send me your CV. Just
Delegate.
turn up. I don't
Yeah.
care about
Turn up.
CVs.
Yeah.
Like just maybe disclose to me that you're not like a serious criminal or something, and that will be enough. But
And I'll say it again, I think it's amazing what you're doing.
Yeah,
And
thank
as
you.
I say, we need
So
more
good.
office. I just think it's fantastic. And
And
as
I
I say,
hope folk
this
reach
spreads
out,
along.
on the back of this, because there's so many dads that, mums as well, but want legal advice and just don't know where to turn.
Yeah.
Even just the paperwork side of things, people
Yeah,
maybe
it's
represent themselves,
intimidating, isn't it?
intimidating
It's-
me,
yeah.
kind of admin stuff.
Yeah.
if anyone wants
Yeah.
to get out, if anyone wants to get in touch, I can at the very least I can guide them behind the scenes on
Oh,
what they
that's
need to
amazing.
do, and people absolutely can represent themselves.
Yeah. Be great to have you back as well.
Thanks
It'd
for
be great to
having
have you
us.
back.
Yeah, we'll come back.
Sure.
Oh, definitely.
Thank you.
Aye, thank you so much for coming on. So,
Thank
great podcast. Anything else,
Yeah,
Dad?
thank you.
you. No,
No,
good here.
that's all. You got my contact details, and and you guys have got my number as well. So I maybe won't publish my number on the podcast right now, but like if there's any guys that you two know directly, you're welcome to share my
I
contact
appreciate
number, and they
that.
can
Okay.
WhatsApp me.
I
Yeah,
appreciate that.
yeah.
Aye.
And obviously, anyone that approaches you, Voice for Dads, it's just a group of dads that are there for each other to talk,
Yeah.
and we can share experiences because we all know kind of how this feels to be in
Yeah.
this situation.
Yep.
And
So-
anybody wants to throw votes to my independence candidate?
Yeah, I know. That's
Change,
it.
change the law for the better.
Indeed.
Right, guys, thank you very much,
Thank you.
and
Aye,
speak soon.
All right. Thanks. Cheers.
Yes.